along with the other evidence that was excluded that we've complained about. Thank you.
Thank you, counsel. Next case on the docket is SAUCIER versus NOWAK.
Good morning. May it please the court. Chad Layton, representing Craig SAUCIER, the appellant. Your Honors, we're here on a family law matter. I represent the father. As a very brief review of where we're at, we have a minor child. That's the most important part of the case. Lacey Ray NOWAK. She is now 2 years old. Father filed his petition to establish paternity prior to the time that the minor child was actually born. He filed his petition May of 2014. The minor child was born June of 2014. There was a relationship, as alluded to in our brief, Your Honor. The relationship was brief. The parties ended their relationship quickly. The father is a member of the United States Air Force. He was ordered by the Air Force to go to Tucson, Arizona prior to the time that the minor child was conceived. Paternity was thereafter established through our law firm October 2015. The issues raised on appeal by father, I'll go following my brief, Your Honor. Number one, the video conferencing schedule.
What did the judge order or not order with regard to video conferencing? Because the brief seemed to argue both sides of that. One
Absolutely.
side says he erred by not doing it, the other side said he erred by doing it. So what is the state of the record with regard to video conferencing?
Thank you, Your Honor. I believe that it's actually very clear on that issue. I have a copy of the trial court transcript. Page 160 of the trial court transcript, lines 3 through 25, as well as page 161, lines 1, the court specifically states, and I have it quoted here, I have the transcript as well, no reason that every night before bed, Lacey shouldn't have the opportunity to talk to her father. Every day, 7 days a week, time on computer with dad. You can expect, and I'm going to order preliminarily, until you see this judgment, video conferencing available every day, period. So our position on that is, Your Honor, that it was a major issue at trial. We presented evidence on that. We presented video conferencing attempts by father. We presented the missed calls, and we presented testimony as well. So the exhibits came in as evidence of his attempted video conferencing that he printed out, as well as his testimony on the issue that, hey, I haven't been able to video conference with our daughter, with Lacey. Mother has failed to make this happen. And we really focused. It was one of the big issues of the trial, and the court ultimately pronounced at the trial court level exactly what we referred to there, that video conferencing is going to occur every night before bed, 30 to 45 minutes before bed. There's no reason for it not to occur. He specifically even states that it's going to be on the computer. That was something that just was not addressed. The court didn't say, hey, we're not granting video conferencing. They didn't address it at all.
And did you file a motion for rehearing to advise the court that they failed to include it in the final judgment?
We did not, Your Honor.
Included?
We did not, Your Honor.
Isn't that the most expedient way to do it? I mean, we have these cases, I know they're with regard to factual findings, but the philosophy behind them is it's a whole lot easier for a judge to correct an error 3 weeks after a trial than having to do it 2 years later if it comes up on appeal and we send it back. Without
question, Your Honor. We would rely on the case law we've cited, and I have it here, but number one, I would agree with that. I think that is easier. That is an area that the judge missed. I would argue based on the case law that there were some other bigger issues that we're here on today, being the parenting plan. That's something that was addressed, and that as we cited in our appellate brief as well as our reply brief, that ultimately there's no competent substantial evidence to support some of the findings in place. That's what we would rely on there, as well as the answer brief filed by mother in this case. She specifically, and I have it noted here, states that she is not arguing or attempting to argue that the issues we've raised on appeal, being 1, 2, and 3, are not proper here for appeal. So we would argue that there's a waiver, and if I may have 1 second, I have it in my notes here. I'm going to reserve 5 minutes for rebuttal, and I'll address at that point, but the answer brief filed by Mother in this matter specifically states that issues filed by us being 1, 2, and 3, they agree, will be appealed. The only issue they argued against was the parenting plan argument. So we'd ask, and I'll address that in my rebuttal time, but we would ask to look at the appeal answer brief filed by Mother and the fact that the argument they've made is that the only issue that shouldn't be heard on appeal would be our argument against the parenting plan, as well as the case law that we've cited.
All right. Let me have you shift to the argument about medical decision-making.
Absolutely.
And I know there was an issue about vaccinations.
Yes, sir.
And my question is it your position that the judge should have given your client sole decision-making with regard to vaccination, or is it your position that it's with regard to all medical decisions, and was there testimony on anything other than the vaccination question?
Regarding the medical, there was testimony provided by the mother as to medical issues, decisions she's made. Her testimony was basically we haven't had any other issues other than vaccination, because I asked her on that issue of where are we at with medical decisions, why is there a problem with vaccinations. Mother specifically testified to the fact that the only disagreement we've had thus far is vaccinations. Lacey's been healthy. So that was her testimony on the issue. Our side was that vaccination was the biggest issue we raised at the point we knew prior to trial that the minor child had received no vaccinations. We had been pushing for vaccinations. Mom refused to place father on the birth certificate at the time of birth, which was a major issue, and we felt played into the role that father had, which was no say in medical decisions, including vaccinations. Ultimately, the court has now ruled they have shared parental responsibility. As we stated in our brief, we believe that's pushing both parties back to the trial court level in some type of enforcement or modification matter. Because they now have shared parental responsibility, mother still is providing no vaccinations to the minor child who's over 2 years old. At the time of trial, she was over 15 months, way past the time that vaccinations were due under Well Baby and the standards that we introduced. But at the end of the day, we were primarily focused on vaccinations. As far as other medical issues, the mother's testimony was there were no other medical issues that had been raised, so it hadn't been a problem to that point. So we focused on the vaccination issue. Mother's testimony...
Is your argument today that your client should have sole decision-making power with regard to medical generally, or just with regard to vaccination?
Our argument is that we are looking for sole decision-making authority regarding medical decisions. And that's what we've stated in our brief, and that's what we would present to the court as well, based upon the decisions made by mother, not only on the vaccinations, but we relied heavily on some of the decisions that mother made to bring a chiropractor in the court. And he was there to attempt to testify what was best regarding the minor child for vaccination purposes. And she indicated she was bringing the minor child to this chiropractor, and that he was able to then, in his primary role at the trial court level, was to testify as to vaccination issue and whether or not mother was right. We objected. We felt that that was not an expert, and I went into extensive questioning with the expert on Boyd Dwyer, as well as whether or not he was an expert. He ultimately testified, and the record showed in our brief refers to the fact that he had never given a vaccination, he did not have a medical degree, and he wasn't authorized to make that kind of decision.
So is it your position that if a parent takes the position that their child should not be vaccinated, they are in essence giving up their right to have any say-so in all the medical decisions of the child, because the state should rule that that's an inappropriate conclusion on vaccination, and therefore they forfeited all their rights to participate in medical decision-making?
Absolutely not, Your Honor. What we would ask is that the court, when looking at parental responsibility, decision-making authority, and then narrowing it all the way down to the medical decision-making authority, that the court would look to, there's two parents. We only have two options here of who's going to make decisions. One would be shared parental responsibility. If everybody's getting along, it's not an issue for the court. If they're not, and there's an issue that arises based on vaccinations, now we need to look at, there's not an agreement here, we need to decide one way or another regarding the parents, and which parent is best suited to make medical decisions for the minor child. We would ask the court to look at the evidence presented here and what we're looking at with a totality of the circumstances regarding what mother's basis was for not providing vaccinations, which her basis was the opinion of a chiropractor and her own research.
Which the trial court concluded was a reasonable position, if I remember correctly. Is that right? Didn't the trial court make some statements to that effect?
I don't believe they did, Your Honor. I'm not 100% on that, but I don't believe, based on our brief and my review of this file, I tried the case at the trial court level as well as handled the full appeal. At the final judgment, in the final judgment, I don't believe the court sufficiently addressed what to do with the vaccinations.
I understand it wasn't in the final judgment, but was there some statement made by the judge during the trial which in essence indicated he thought her position was not unreasonable?
Yes, I believe there was. We don't agree with that statement, but yes, I do believe the judge did make a statement during the trial to the effect
Is that a factual decision or is that some legal decision? I mean, is it your position that under no circumstances could a judge properly say it's okay for this vaccination policy to occur?
Absolutely not. We would lean on the facts of this case, and we're not here to set a precedent that would apply in every case in Florida, specifically in family law. Again, what my focus...
Well, of course, the problem is if you ask us and we write an opinion,
it's going to apply.
It's going to have to apply across the board, so we have to look at what's the principle of law, what's the standard such that in this case it was error for the trial judge to do this, and if so, is that an across-the-board statement, or is there something unique about this case that makes it not precedent for other cases?
Well, number one, we would ask that there be a presumption in favor of vaccinations. Number one, we feel there should be a presumption in favor of vaccinations. In my research preparing for this hearing and preparing the brief at the trial court level, I did not find case law going either way on it, that there should be or should not. But we would ask that there should be a presumption in favor of vaccinations. And number two, looking at the parents here, the basis that mother used, I think the court should look at. If in some cases there may be a better basis for not providing vaccinations. If there's specific medical concerns by the mother or by either parent, those should be looked upon. In this case, none of that was risen. There was no evidence, statements, or facts presented that there was good reason not to have vaccinations for the minor child. We further argued in our brief, and we would argue to the court today, that father is unable to have the minor child in any type of child care in Arizona because they won't accept her because she doesn't have the vaccinations.
Now, the mother's position wasn't never vaccinations, it was timing, right? As I understand.
She was very open-ended on that, and I have page 90 of the trial transcript, 1 through 10. Mother testifies, at 2, she will receive vaccinations. Some of them, the ones that I feel are necessary, could help her. Some are worthless. So that was mother's testimony on the issue, and that's where the judge, we would feel, if you look back at the judge's statements during the trial court level, he indicated, hey, mom's going to have all the vaccinations necessary in good time, and I think that's reasonable, to that effect. Don't quote me word for word.
And she would have all the vaccinations necessary for the child to get into school, for example?
I believe she made a statement to that effect. The specific quote I had prepared for today was, at 2, she will receive vaccinations. Some of them, the ones that I feel are necessary, could help her. Some are worthless. She's well past 2. At the time of trial, there were none. I believe as we sit here today, there are none. But on that issue, again, we would ask the court to look at all of the facts, all of the circumstances. I understand your question that vaccinations is an issue that arises around the country. I don't have the clear answer on how vaccinations should be decided in every case, but I think the facts of this case, and probably in other cases, should be looked upon. There were no facts, there was no evidence other than a chiropractor that we argued in our brief, and we would argue today, if anything, further exacerbate mother's poor decision-making authority.
What testimony did you present as to the necessity of vaccinations or something contrary to what the chiropractor said the other way, assuming the chiropractor could even testify to it?
We presented the father's testimony on the issue, that he felt vaccinations were proper, but we did not bring any expert testimony in. It's an area that we suspect and we would ask for a presumption to be in favor of vaccinations. We didn't present an expert. We would argue there were no experts, but again, the ability going forward, the ability for mom to make medical decisions for the minor child, we have, again, 2 options here, and we would ask the court to pick one of the 2, and we feel the father is clearly better suited to make strong decisions medically for the minor child because the mother had no basis for not providing vaccinations, and then she brought in a chiropractor to...
Well, you say she had no basis. She said her basis was what the chiropractor said. You can argue
yes, as well as her own research.
The chiropractor is qualified or not, but she had a basis. Right?
That was.
Her chiropractor said they weren't necessary at this point in time.
Yes, Your Honor.
And that was up against no testimony on your side, right?
Other than the father. other than the father. And we would ask the court, if possible, to take judicial notice, and we would ask the court.
Certainly not be any more qualified than the chiropractor. Maybe the chiropractor is unqualified to give a medical opinion, but the father would similarly be unqualified if that's the case.
Absolutely,
right?
he's not an expert, and there would be no expert testimony from father. It would be fact evidence on what he feels is best for the minor child, and for the court to look upon his ability going forward to make decisions for the minor child, because we're not looking at just this one now. We're looking at, this is a very young girl, and how are we going to make decisions for her going forward? We believe father has shown a better ability to make those decisions for the minor child. Next, we have the parenting plan under the factors provided by Florida Statute 61.13. The final judgment does not address the unrebutted testimony and documentary evidence. Number one being the missed video conference calls father attempted with the minor child that were presented through his testimony, as well as the actual exhibits were presented in the court. Number two, the medical decisions by the mother. Her decision to deny vaccinations, we believe, is against the best interest of the minor child. There was nothing we saw in the trial court level to show that was in the best interest of the minor child. We believe mother is putting her own interest in front of the best interest of the minor child. Refusing to put the father's name on the birth certificate.
What about the evidence from the chiropractor? He
We
was allowed
believe,
to testify, correct? His testimony wasn't stricken.
no,
So the trial court had before it his opinions
Yes.
on the vaccination. So how can you say there was no evidence upon which the court could decide that the vaccinations were not required?
just looking at the record, he testified when I questioned him, he had never provided a vaccination to anybody. He wasn't allowed to penetrate the skin of anybody.
But you didn't move to strike his testimony, correct? You cross-examined him, but
Well, no,
his
prior-
testimony on direct is still part of the record that the court can consider if it's not stricken, correct?
Yes, but I would say we did more than cross-examined. Prior to him testifying, I asked for the opportunity to examine him to determine whether or not he was an expert. The court allowed it. I went in at length to examine him, and the more I examined him, the more that I felt it became apparent that he was not an expert and should not testify. The judge disagreed, but I did go at length, probably more than 10 minutes, Your Honor, and the more I asked, the more I wanted to ask, because in my opinion, it became more and more apparent he had no business testifying on vaccinations when he was not able to give vaccinations. He had never given a vaccination, and he was a chiropractor. Mother was testifying to the effect that she was bringing the minor child to this person for medical care, which I think should raise the eyebrows of the court and should severely put her decision-making ability in question. And when you have another person being the father, I think that's the best person in this case to make decisions.
You're down to about 3.5 minutes if you want to save it for rebuttal.
Yes. Thank you, Your Honor.
Good morning, Your Honors. Greg Tucci from Ocala, representing Ms. Nowak.
Mr. Tucci, before we get into a lot of these other issues, I want to talk to you about the imputation of income issue. And what we have here is a trial court saying one thing in an oral pronouncement and maybe saying something different in the written judgment. And according to my notes, the trial court basically orally ruled that he was going to impute something like $10 per hour for the mother's income, and then in the order it was going to be the minimum wage. So is there a conflict there, and how do we resolve it? Send it back and let the trial court specify, or what?
Well, the trial court didn't really say $10. He left it open-ended. He said he'd have to impute.
Well, he said this. I thought the trial court specified that, and I'm quoting from my notes from the memo, that it intended to impute an income of full-time employment concerning what her employment was in the past of $10 per hour to the mother. And then, in the written judgment, the trial court imputed to the mother income based on minimum wage.
Well, maybe I misremembered whether it was $10. He was going to impute something. I didn't remember.
Well, if the trial judge orally rules that it's going to be $10, and then in the written judgment it's minimum wage, don't we send it back? And
No, you don't in this case.
how do we resolve that then?
Well, here's the problem, Judge. We did not waive anything with regard to issues 1, 2, and 3. My client specifically in our brief claimed that the dad had waived these arguments because he didn't file for rehearing on any one of them. which is the proper mechanism based on the cases cited in the brief. To try and get out from under that, in response to the answer brief, their reply brief indicated they didn't have to file for rehearing because they were going under Rule 1.5.
So your position is that even if there was an error here, that it was waived because they had properly raised it in the motion for rehearing?
Correct, and you can't get back in the door going under 1.530E because there's sufficient evidence for every point, 1, 2, and 3, that they've raised. The record is full of sufficient evidence on those points.
What case law do you have that a motion for rehearing is required
Yeah,
if the trial court omits to rule on an issue?
Yeah, it was,
I don't think I had a case specifically on that
I mean, there are
point.
cases that say if you're going to argue on appeal, inadequate facts put into the
Correct.
final judgment, then you got to do a rehearing so the judge can put the facts in. But I don't, is there any case law that says if he totally fails to address an issue, we can't do anything about it, or if he does it contrary to his oral pronouncement?
Well, I don't have an exact case on that point.
well, there's a specific case, you know, that's cited in our memo that basically, and I think there are other cases that say that when the oral pronouncement conflicts with what's in the written judgment, it's reversible. It should be reversed and sent back.
I agree, and I conceded that. I conceded that point
Okay.
if, in fact, the issues 1, 2, and 3 were properly preserved for appeal. But I don't think, if you don't, I mean, you're supposed to go back to the court on a rehearing and say, Judge, you made a mistake. Fix it. I mean, that's what all the cases say. And that was...
Don't some cases say if it's a non-jury trial, you don't have to do the rehearing?
That's the 1.530E. But that's where there's no evidence. For example, in the Achura case, I think that's how you pronounce it, cited by the father, what happened was the trial court entered a permanent injunction against domestic violence based upon something Dior's the record, and there was no evidence to support the entry of the judgment, and the appellate court under 1.530E reversed that final judgment. Here, we have three issues where, for example, you asked the minimum wage.
Yeah, I mean, the only point that I'm trying to make is that to me, there is a conflict in between.
I agree. I agree.
You agree with that, yeah.
I agree with that.
You're saying he has to file a motion for rehearing in order to preserve it.
Correct. And you can't get back in under 1.530 when you've got sufficiency of evidence. I mean, there's competent substantial evidence. For example, video conferencing. I know what the court said. It didn't include it in the final judgment. The remedy, in my opinion, is a motion for rehearing to point out, Judge, here's what you said and you forgot to do it. You can't, I don't think you can come back under 1.530E and say, well, I didn't do a rehearing, but I can come back in the back door because I'm going to claim there's insufficient evidence. Well, there's not insufficient evidence, and that's what that rule says. It doesn't say, well, he left it out, so you can still go challenge it. I don't think that's...
What was the evidence contrary to the indication that she could earn at least $10 an hour?
There was no evidence contrary. I don't disagree with that. I mean, I concede that was actually the court reporter got it wrong. When she said $10 to $15 an hour, you read the transcript, they say the dad testified to that. I concede that was a typo by the court reporter. Actually, she said that. She also said...
So there was no evidence to support the imputation of just minimum wage then, right?
I agree.
Okay.
I agree with that.
She was voluntarily unemployed, and, you know, and the testimony was that, I forget what her prior employment was, but she had been previously employed.
A phlebotomist.
Okay, and she was earning between $10 and $15 per hour. And the
Correct.
trial judge said orally, I'm going to impute $10 per hour. Then suddenly, in the final judgment, it's minimum wage. So where is the I mean...
Motion for rehearing is the appropriate remedy. I don't believe 1.530E is a way to finagle yourself back into court when you could have corrected it under...
Did you draft the final judgment, or did the court draft the final judgment, or somebody else?
The court requested both counsel to submit a proposed final judgment. The judge did his own judgment.
Okay. He didn't sign the one submitted by you
Obviously not.
on that issue.
On any-
What's your position as to video conferencing? Is there an order in place now for video conferencing? Is it your position that your client has no obligation to do any video conferencing now? What's the status of the record?
The record is there's no order right now for the video conferencing.
There was an oral ruling, but it didn't make it into a final judgment, correct?
Correct.
And it's your position that the oral ruling is not controlling at this point?
I probably can't answer that without going outside the record.
My question is whether or not the oral, I'm not asking what
I
you're
don't think
doing or not doing.
Yeah.
Based on the state of this record, does your client have any obligation to allow the husband to have, the father to have any video conferencing? Or is it your position that based on this record, she does not have to allow him to have any video conferencing?
My position is she doesn't have to allow him to have video conferencing.
What about the basic rule that says that oral pronouncements control over what's in the written judgment? You have to go back and make sure that they reconcile. If the trial court orally ruled that they were entitled to video conferencing, but it's excluded from the order, don't we send it back and put that in the final judgment? And then I guess the question is, should the trial judge include a schedule for the video conferencing?
Well, the judge had a schedule for it.
Pardon?
At least in his oral pronouncement, he had a schedule.
But you say that's not operative, right?
I don't believe it's operative.
You're saying the trial court's prior ruling in the record that they were entitled to video conferencing is basically meaningless?
If you enter a final judgment, you don't include it, and you don't ask for a rehearing, I don't think it's really operative. I may be wrong, but, I mean, if you get a ruling from a court, you abide by the ruling.
Would it have been, if that's in fact your position, is it reversible error for the trial court not to have established or allowed for any video conferencing? Would it be an abuse of discretion? Would it be in the best interest of the child to not have any video conferencing contact with the father?
I don't think that was an issue because at least to reasonable video conferencing, the mother testified she was fine with that.
But she's not required to do any of that, even what she thinks is reasonable, right? Under your philosophy, if she chooses to allow no video conferencing at all, that is consistent with the final judgment. And if that's the case, is the final judgment erroneous because it doesn't provide the father with any contact schedule with the child?
Unfortunately, I think that's correct because there is sufficient evidence and there was no motion for rehearing and you can't come back in under 1.530 in my opinion. But that's why I'm here and not there.
Is there what other contact is set forth in the final judgment? What's the contact allowed in the final judgment separate from video conferencing?
Boy, I wasn't ready for that. He has quite a bit of time in the summer.
Right.
I believe he has 3 days a month where he can visit with the child. There may be some other visions, but I honestly didn't reread those provisions.
So under your interpretation of the final judgment, if he gets his 3 days a month, he's not entitled to any other contact with the child during the month. And if the mother were to say, you get no contact with him except those 3 days, she wouldn't be in contempt and she wouldn't be in violation of the judgment. Is that your position?
I'm inclined to think so.
And if that's in fact what the judgment means, would that mean the judgment is erroneous because it is not in the best interest of the child to limit the father's contact to only 3 days a month with no right to have contact during the rest of the month?
Well, yeah, I'm not going to back myself in that corner because I understand the dilemma about the rights of the dad and the best interest of the child. I'm stuck with a
I mean,
procedural issue.
that's one of the problems with arguing the procedural rule in this context, right? The trial judge has to look out for the best interests of the child. So
Correct.
even if you think there's some procedural hook on which you can say the father didn't do something he should have done, the trial court still has to look at what's in the best interest of the child,
I
correct?
don't disagree, but I'm compelled to make the argument that there's factual, sufficient findings of fact that would normally preclude using 1.530E to raise these issues for the first time on appeal, but that's going to be subject to this court's interpretation.
Those cases
obviously.
that say inadequate factual findings are in essence waived if you don't file a motion for rehearing. Are those cases on issues related to custody or visitation, or are those on financial issues like alimony and that sort of thing?
I think most of them are on financial issues, based upon my recollection of the case law. The primary issue we raised on cross-appeal was the failure to award retroactive child support to the mother. And the basis of, again, the final judgment was that she didn't ask for it, in layman's terms. We did file a motion for rehearing on that very point, which was summarily denied. And it's set forth in our brief. The father selected paying $300 a month, and
Where in your pleadings or where in argument to the court before rehearing did the wife ask for it? I'm sorry, the mother asked for it? The
She-
retroactive alimony?
no, child support.
Child support,
She asked
sorry,
for
child
it, she asked for it in her pro se answer. And I cited in the brief her exact language.
And was that pursued during trial as well?
Excuse me?
Was that pursued during trial as well?
Yes, yes. We requested it at trial. And her pleadings contained, I specified the language, she wanted support in terms of the guidelines, in layman's terms is what she asked for. And the judge said she didn't ask for it. Well,
Well, asking for support and pursuant to the guidelines doesn't necessarily mean you're asking for retroactive either. It's just that guidelines are how you calculate it, right?
well, here's the problem with
So
retroactive.
are you saying that she specifically requested retroactive in her answer?
No, because her answer was filed 2 weeks after the child was born.
Well, I thought you just said that in her answer, in her pro se answer, she requested the retroactive.
Not retroactive. I misphrased that. She requested child support based upon guidelines, or language to that
Okay,
effect.
so it goes back to the question, did she specifically request retroactive in her pleadings anywhere?
No, because at that point, there was no retroactive. He filed his petition before the child was born. The child was then born, and within a week or two...
I know, but then once the child is born, you can come back and request retroactives. In some form or fashion in the pleadings, you can do that. You can file a supplemental pleading or ask it be amended or whatever.
But she asked for child support,
Okay,
right?
she asked for child support, and you're saying that in the trial proceedings, she specifically, during the trial, that she specifically asked for retroactive.
Well, probably a word of art, but yes, we wanted it to go back from the date of birth of the child. And she filed her request for child support within 2 weeks of the child being born. So technically, there wasn't any retroactive due at that point in time. It was going forward. And he specifically testified, he decided on $300 a month, that's what he did. And the first couple of months, she sent him emails with what things the child needed, and he went ahead and bought those things, and it seemed to come out to $300 a month on average, and then he just continued buying or sending $300 a month, either money or things. And when I asked him, how he arrived at $300 a month. He responded, when I would purchase things, the amount usually, I would try to keep it at around $300. She, meaning the child, was young and feeding at that time and wouldn't require a lot of food or other things. That was in trial transcript R37. So he set the tone. It had nothing to do with her other needs, with housing, with things like that. So I don't think the record supports a finding that she didn't request retroactive. I mean, typically you ask for something in your original pleading. You don't normally, I'm not familiar with normally amending it.
I mean, if you've got a case like this and all you ask for is that the child support be awarded, but you don't ask that it be awarded back to the date that the child was born, you're just asking for child support. You're seeking a claim or relief that's not specifically requested in the pleadings. How is a trial judge supposed to award it? Is this automatic?
Well, the case law that
Say for example, a child is born, and then there are paternity proceedings, and then the answer is filed, and the answer doesn't include any claim for retroactive child support. Does the trial judge just automatically award it?
based on...
Does it have to be requested in the pleadings?
Child support was requested in...
No, I'm talking about specifically, does it have to request retroactive?
I would think not, based on the case law I've submitted. I would, particularly when you file your answer about a week or two after the child's born, and you include a request for basically guideline child support. There are several cases cited, the Williams case, Johns v. Richards. They're all in the brief, and there's one case. All those cases say that a denial of child support, retroactive, or any kind of child support, going back, retroactive meaning going back to the day you requested it.
Well, I think the issue is if you didn't raise it in the trial court, then it's inappropriate to raise it for the first time in the appellate proceedings. So you're saying that it was raised simply by the virtue of the fact that she asked for child support.
Correct.
Your theory is that automatically requires retroactive application.
That's
if you
what
didn't argue, but you didn't argue retroactive application, and you didn't present the calculations as to what that amount would be, and you're raising it for the first time on appeal. Why are we authorized to even hear that issue?
Well, because I filed a motion for rehearing as to the failure to award the child support.
Your time has expired, thank you,
Yes,
sir.
sir. Thank you, Your Honors. I'll try to move.
You don't have much time left, but just Mr. Tucci is saying that for example, when we go back to the imputation of income, that
Sure.
really that wasn't raised in a motion for rehearing, therefore you waived it. Although he concedes there's a discrepancy between the oral pronouncement and the written judgment. But you didn't raise it in a motion for rehearing, therefore you waived it. You want to respond to that?
Yeah, quickly, I want to make sure I understand your question and respond properly. On the retroactive child support issue, I want to make sure that the record is clear on that. Counsel stated mother filed a pro se answer requesting that. That did not occur. What happened was the minor child was born June 13, 2014. July 15, 2014, counsel actually filed the first answer for mother to this action. It's attached to the motion for rehearing that he filed. He attached his original answer that he filed at the trial court level. He did not at any time, and mother did not at any time request retroactive child support.
Well, retroactive child support normally goes to a period back before the suit is filed, right?
Yes.
If the child's a year old and I file a petition and ask for child support, the standard is I get child support from the day I filed the complaint. If I want it back for the year before I filed the complaint, then I ask for retroactive or child support in arrears, right?
That's my understanding, Your Honor.
So in this case, we're not talking about we're really not talking about retroactive child support. We're talking about child support back to the date of the pleadings, not back to the date of birth. In this case, they happen to be within a couple weeks of each other. But
Right,
normally, when you ask, if I ask for child support, I'm entitled to it from the time I filed my petition. I don't have to ask for retroactive if it takes a year to get to trial. Would you agree with that?
Yeah, my general, and I may be semantics, my general understanding when I practiced was if they're no longer under the same roof, once they file thereafter requesting, generally still, once you're no longer under the same roof, once you file, if I file in August of 2016 and my client was no longer under the same roof in January of 2016, I'm asking for future child support, and I'm separately asking for retroactive child support dated back to the date I place in there, when they were no longer living under the same roof,
Okay, but
depending on the
But from the
circumstances.
date you file your petition forward, you don't, that's not retroactive child support. That's about, your normal claim for child support goes back to the day you filed the petition, right? Even if it takes you 3 years to get to trial.
Right.
If you ask for child support, or if you ask for alimony, for example, the date the court is supposed to use to award it to you is from the date you filed your petition, not from the date of the trial, right?
On that issue, what I would say is I believe the court has the discretion on that issue of how they're going to award that, and I specifically have here some brief points that were presented to the trial court and that were considered at the trial court level on that issue. What occurred in the court looked at, number one, court stated specifically, mother did not plead at any time for retroactive child support. The judge said that on the record, and that was one of his basis for denying retroactive child support. Number two, he went into other issues, which were that father began paying child support immediately. When the child was born, father began paying child support to mother, began providing specific items, and the evidence was presented to the court of what he provided, the payments he made. Next, mother decided not to put the father on the birth certificate, and evidence was presented on that issue that the minor child would have immediately received TRICARE benefits under the father's employer, which would include health insurance, additional pay to father, as well as all out-of-pocket expenses for the medical for the minor child. So those issues, when you look at the transcript, and it's specifically page 28, line 1 through 20, father specifically testified to the fact that mother denied and did not put father on the birth certificate resulted in some major losses to the minor child, including income to father to help pay for child support. All those were considered by the trial court judge when he denied retroactive child support. And when you look under the law, the judge has the discretion on that area. So he stated, number one, they didn't request it. And when you look at the motion for rehearing filed in this matter, you'll see the answer that was originally filed by mom. There is no request for it. But not only that, number two, mom did not put dad's name on the birth certificate. Dad traveled all the way to the hospital to be there. His name was not there, and that denied dependent pay as well as TRICARE benefits to the minor child. And dad started paying from day one. So all of those fall under, and I would say the law is, it is to the discretion of the trial court.
Before you exhaust your time.
Yes,
I
sir.
wanna
He
get
already
back-
has, but go ahead.
Okay, I want to get back to the original question I asked. There's a discrepancy in the oral pronouncement.
Yes, sir.
And then there's a and that's not included in the written judgment. For
Yes, sir.
example, the trial judge said, I'm going to award $10, and instead awards minimum wage. Mr. Tucci's argument is that you waived that because you didn't raise it in a motion for rehearing. So respond to that real briefly.
Absolutely. The answer filed by Mr. Tucci, and I should say Appellee's answer brief and cross appeal, they have specifically in their summary of argument, the father has waived for purposes of appellate review any objection to the final judgment, not including a video conferencing, and then he gets into specifically issues 1, 2, and 3. We interpret that as a waiver. We'd ask the court to look at the answer filed in this matter. And then number 2, specifically and quickly, very briefly, the law. 1.530E specifically states where the record does not support the findings of the court and the ruling of the court, there is no need for a motion for rehearing. We would rely on that, as well as specifically the case law cited, Brewer, as well as I'm sure I'm mispronouncing it, Mahaffey and Welch, that all say there's no requirement for the filing of a rehearing when there is not evidence to support the findings by the court. And in this case, we certainly rely on that as well as the waiver filed there. Thank you for your time.
Thank you. Well argued on both sides.
Court will be in recess.